Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with notice. Now I am specifically going to go over all about notice in the GAR, Georgia Association of Realtors contracts, but the ideas are substantially the same in the RE forms contracts. So why is notice important, and what should you do as an agent when you first go binding? Well, notice is important because that is how one party notifies the other party regarding something to do with the contract. For example, the idea to use notice to inform the other party of something with respect to the contract is mentioned throughout the purchase and sale agreement. For example, it states right to extend the closing date. So if one of the parties is going to use the 8-day unilateral right to extend the contract, in paragraph B4 under that, it says that the party unilaterally extending shall state the basis for the delay in the notice of extension. If there is an issue with the title, under the paragraph B2, where it talks about the buyer having the right to examine the title, if the buyer finds an issue with the title, it states that the buyer must send the seller notice of the issue with the title to give the seller the right to cure, so forth and so on. So another place it talks about notice is if a party is going to terminate a contract under an agreed upon contingency, then that termination must be done by notice within the time frame that the parties had agreed upon. So the idea and the concept of notice and how to properly give and receive notice, or give notice, is very, very important. So what is notice? What does it say about notice, and how do we know what to do and how to do it properly? Well, again, in the GAR contract, it is under paragraph C1 where it talks about notices. So there's a couple of things. I'm going to go over all of them, and then I will summarize. The first thing it states is that notice must be done in writing, it must be legible, and it must be signed by the party meaning the buyer and or the seller. Now, notice in and of itself is unilateral, meaning you only need one party's signature. When a contract says it must be done by agreement, agreement means both parties. An amendment would be an agreement. An amendment to the contract would be an agreement and would require both parties' signatures. But a notice, by definition, is unilateral and only requires one party's signature. The majority of the times, the notice is being sent from the buyer to the seller. There are some exceptions, but in general. So must be in writing, legible, signed by the party giving the notice. In other words, an agent, you guys, email to email agent does not satisfy the terms of notice per the contract. So if you send an email to the other agent saying your party is going to terminate the contract and you're doing it prior to the end of the due diligence time frame, doesn't satisfy the terms of notice. And if you don't send that notice in writing signed by the buyer, you do not have a terminated contract. So that's the first thing it states. The other thing that it states is it must be delivered one of three ways: either in person or by a overnight delivery service, courier, or if you're going to send it U.S. mail, it must be certified or registered. And then if you're going to send, the third way is electronically, either by email or fax. Notice, pun, there is nothing in there about telephone notice. So notice by telephone does not constitute notice per our purchase and sale agreements. And that's true in both the GAR contract and the RE forms contract. Now think about it. How do you send a text? You send a text through the telephone. Right now, text is not considered notice in writing, and it's considered telephone communication and does not satisfy the terms of notice per our contracts. Now, the other thing about notice, so that's how, must be in writing, legible, signed by the parties, and it must be done in person, by overnight service, courier, or in the case of electronically, email or fax. Then delivery of notice. Well, how do you know when it is actually sent, and what does the contract define as it being actually received? Well, the contract clearly defines that, and it says notice to a party shall be deemed to have been delivered and received upon the earliest of the following. If it is the actual receipt of the notice by the party, for example, if it was in person, in the case of delivery by delivery service, the notice is considered received when it is delivered to the address of the party receiving the notice. So in other words, if you are sending something by mail, overnight delivery service, or courier, you must have some means of tracking when it is actually delivered to that address, because just when you send it is not, in this case, it's not considered sent, it's considered when it is actually delivered to that address. So you would get a something back from the delivery or overnight or courier service indicating when it was actually delivered to that address. Now here's the thing, most of you guys are sending notice electronically, and most of y'all are doing it by email. So what does it say about email? It states, in the case of delivery electronically, notice is considered deemed delivered and received on the date and time the written notice is electronically sent to an email address or fax number of the party herein or subsequently provided per the terms of notice. Notice to a party shall not be effective unless the written notice is sent to an address, fax number, or email address set forth herein. Okay, so a couple things about that. It is deemed to have been received when the sender can prove they sent it, not when the person receives it. That's one thing. The other thing is it must be sent to the place as indicated in the contract. So you need to look at the signature page of the purchase and sale agreement. And in the case of electronic, if you're sending it by email, it must go to the email address that is printed on the purchase and sale agreement of either the agent or the party. And I'll get to that part in a second. That's another part of notice. So, well, I'll come summarize that in a minute. And then the next section is when can the broker, and broker is defined in the contract, meaning either the firm in and of itself or the actual person who is the broker of the firm or the affiliated licensee of the broker, which would be you, the agent. So anytime the word broker is used in the GAR purchase and sale agreement, it means any one of those three. So the next section where the contract goes on to describe is when is the broker or you as the agent authorized to accept notice on behalf of the party. So not give notice, giving notice must be signed by the buyer or the seller, but to receive it. So it states that if you are working with your public person in a client relationship, so if you're working with a seller and you've signed a listing agreement, if you're working with a buyer and you've signed a buyer brokerage agreement, then notice to you as the agent does serve as notice to the party, as long as that notice was sent to your email address on the signature page. When is notice to you, the agent or the broker? Now also, notice to the broker also serves. So I'll get to that in a second. When is email to you, notice to you, not deemed received by the party? So in other words, if you're sending the notice, if you're the sender of the notice, when would you not send it just to the agent? So if there is a client relationship, you can send it just to the agent. The broker cannot receive notice on behalf of the party if it's a designated agency situation, or if it is a dual agency situation, or if the brokerage is working with the public person as a customer. And all of that, it says, except where the broker is acting in a dual agency capacity, the broker and any affiliated licensee of the broker representing the party in a client relationship shall be authorized. Notice to an authorized agent shall not be effective unless the notice is sent to the address, fax number, or email address of the authorized agent. It also states that notice can be received by the staff at the actual brokerage or the office. The broker shall not be authorized to receive notice on behalf of a party in the transaction in which the brokerage engagement has not been entered into. In other words, when the firm is working with the public person in a customer relationship, or when the broker is acting as a dual agency, in a dual agency capacity. In the event practicing designated agency, only the designated agent can receive notice, not the actual firm or staff at the firm in and of itself. So what does all of this mean for you in practice? Well, when you receive a contract and you first go binding, both agents should do this. First thing you should do, look at the front page and make note of the agency relationships in the contract. If the agency relationship on the front of the contract says that the broker is working with the public person as a client relationship, then you know notice can be sent to the agent. If it's not, as long as it's not a dual agency situation, and designated agency must go to that person. Then what you do is you flip to the signature page, and you need one of three pieces of information. You either need one, a physical address, so you can send notice by courier service, overnight delivery, or in person, or you need an email address, or you need a fax number. So you need one of those three pieces of information. And if the broker is working with the public person as a client, then you need one of those three pieces of information for the agent working with the seller or the buyer. Now, if that's the situation, you have to be careful. When you are communicating with your co-op agent, check the email communication, the email address that you are receiving from your co-op agent. Double check if that is, and for your own email address, is that the email address that is printed on the purchase and sale agreement? If not, you need to send notice about which email address satisfies the terms of notice per the contract. That's the first thing to pay attention to. The second thing to pay attention to is if your purchase and sale agreements auto-populate with your company's fax number, then that is another form, another way that the other party can send you notice. So most companies, if it is the company fax number, most companies' fax numbers are monitored Monday through Friday, 9 to 5. So if a notice is sent, for example, after Friday, after 5 o'clock on a Friday, you might not receive it until Monday. So if that's not the way you want to do business, because you're not personally monitoring that fax number, make sure to not have that fax number print on your purchase and sale agreement. Now, the other thing, if the front of the purchase and sale agreement states that it is a designated agency situation, then it must go not to the brokerage. It can't be delivered to the firm, can't be sent to the firm's fax number, but must be sent directly to the agent working with either the buyer or the seller. And if the front of the contract under the agency section says that the company is working with either the buyer or the seller as a customer, then notice must be sent to the customer. So on the front page of the purchase and sale agreement, if you see a customer relationship under the agency section, first thing you need to do is flip to the signature page. And for that public person that is working with that brokerage as a customer, you need, again, one of those three pieces of information. You either need that buyer or seller's email address, physical address, or fax number. Now, just because a company is working with a public person as a customer, again, this is for terms of notice. It must be sent directly to the customer. That doesn't give you authorization to bypass the agent. That public person has hired that brokerage firm to work with them and represent them. It's just that they are representing them in the capacity as customer and not as client. But in terms of notice, you still have to send notice to that person, but you're also going to cooperate and work with that agent. So there's a lot that has to go on to notice. Again, to summarize, first thing to do, check out the agency descriptions on the first page of the contract or wherever it is in the contract. Then you need to look at the signature page and make sure you have one of those three pieces of information, either a physical address, a fax number, or an email address. And then being able to use, and if you're working with a co-op agent, make sure that that email address on the signature page matches the email address with which you are actually communicating on a day-to-day basis with that co-op agent. And then you have to also remember that in the case of electronic delivery, that email is deemed received when the sender can prove they sent it. So you senders, make sure that if you're sending an email that you can prove that you have that attachment on that email. If you're sending it in the case of electronic delivery, you definitely need to make sure that you get some sort of certification or proof that you emailed it to that email address on the signature page with that attachment of the notice. So hope this contract tip helped you out. It's a really, really important concept within our purchase and sale agreements. If you have any questions, again, please refer to the section on notice in the contracts as it is fully described. And if you've been in any of my classes or watched these videos, you have repeatedly heard me say that the contract is a set of instructions on how you are to operate. I think that's it. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. Hey, Naomi.